afternoon, everyone. I see we have one person still connecting. If you could hold on a moment. All right, good afternoon, everyone. This is Magistrate Bocelli. I've let in everyone who was in the waiting room. If you're not here for the 1 o'clock, which is 20 CA 5273 Dupree versus Edison Insurance Company, let me know that now. Otherwise, I will note that this is being live streamed to YouTube in order to maintain public access to the court. So please keep that in mind. We have Michelle Parks of Esquire as our court reporter today, and she'll have the official record of our proceeding. I'd like to get appearances starting with counsel for plaintiff. You need to unmute yourself. I can't hear you if you're speaking.
Oh, I'm sorry. The hazards of Zoom. This is AROSE. I'm appearing on behalf of the plaintiff, Ada Dupree.
Thank you. And for the defense?
This is Veronica Hickey, appearing on behalf of the defendant.
Thank you. And then I see we have Jesse Diaz. Are you here for the 1 o'clock?
I have it on my scheduler that I have a motion to compel hearing at 1, but I'm looking at my email, it says it's 2 p.m. It's for the McAllister matter.
20C, yeah, McAllister versus Safe Harbor is on my docket at 2. I didn't.
Okay, yeah, that's an error on our end. I'll change it and I'll be there. Bye.
All right, thank you, Mr. Diaz. All right, so back on the record in 20 CA 5273, this is plaintiff's motion for protective order as to scope of deposition of CMR dated March 26, 2021. The order of referral was April 19th, 2021. I'll turn it over to plaintiff's counsel for argument.
Thank you, Your Honor. This is a case that we brought on behalf of Ms. Dupree due to unpaid insurance benefits as a result of Hurricane Irma. There was damage to the property, including but not limited to the roof of the home. We have named as our expert with respect to scope and recommended repairs, CMR, construction, and roofing. Defendant filed a notice of taking their deposition. And we have an issue with the scope of the areas of inquiry and the documents requested that CMR produce. Schedule A of the notice included topics to be discussed, which would include the general business practices of CMR, as well as the general handling of CMR of other residential properties, including estimates they may have performed at other properties that are completely unrelated to this claim as a result of, I have to assume, Irma. I don't know, it's extremely broad. Schedule C requests that that CMR prepare a list of all lawsuits, which it has been personally named as a party over the last 3 years, and a list of all matters in which it has been deposed in the last 3 years. So going back to the areas of inquiry, the Rule 1.280 is very clear with respect to the scope of expert discovery, that only in really very limited and compelling circumstances should experts be required to discuss their general business practices and or financial matters which are unrelated to the particular matter which they are retained. Defendant has not explained at all why these areas are necessary for the deposition, which is extremely limited in scope. Certainly the handling of other cases that they have been involved in for work that they have done is, and how much they've been paid for. I don't even know which cases. I mean, it's such a broad, it could technically be from the inception of their company. And I mean, a list in which cases they've been named as a party, that's so beyond the scope. They're not even named as a party in this case. And again, matters which they've been deposed in the past 3 years is extremely broad and not relevant, nor would it lead to the discovery of admissible evidence. So for those matters, Your Honor, we're seeking a protective order with respect to those areas of inquiry.
Excuse me. Okay, I had a response from the defendants.
Yes, hello. Plaintiff's argument really circles around the fact that, or the statement that CMR has been designated as their expert trial witness in this case. However, this motion was the first that defense became aware of this, as no expert disclosures have been filed or made yet in this case, nor are they due. We set the deposition of CMR as a fact witness, as you know, in this particular case, they inspected the property and signed an agreement with the insured prior to the claim being reported. CMR was also present at the defendant's inspection of the property, and they also sent an estimate to Edison pre-suit. So we were not planning on deposing them as an expert at this time. We're not paying them as an expert. We don't even have expert opinions yet on this case. So, you know, to the extent that plaintiff is going to designate them as an expert, we were not aware, and that was not the point of setting this deposition at this time. We would ask to reserve the right to depose them based on them being designated an expert later down the line. As like I stated, we do not currently have any expert reports or opinions on this case from either side. So, you know, our areas of inquiry are really regarding the deposing them as a fact witness. Later on in plaintiff's motion, they state that they are objecting to the business and financial records of CMR. That's not even in our notice. We're not seeking them at this time. Of course, if and when they're designated as an expert, we may seek some things along those lines, obviously within the limits of 1.280.
Any other response?
Yes, I'm actually a little surprised by counsel's representation that we did not notify them that they were designated as an expert. Ms. Hickey, I don't remember if I spoke with you specifically, but I know that I spoke with your office and we had a conversation in the attempt to avoid this hearing where I informed you that they were going to be listed as that we were designating them as an expert. So whether you intend to depose them as an expert or not, I mean, we have a deposition scheduled on May 4th. So I guess I'm a little bit confused about you reserving your right to depose them. It's already on the schedule, which is why we're seeking the protective order. And your notice does include the general business practices of CMR, as well as the scope of other testimony and documents, which are just not relevant to this action, nor are they proper as it relates to this witness.
Okay, I have a couple of clarifying questions. So I looked at the notice that's attached to the motion, and it references the attached schedules A, B, and C as document requests. But when I read Schedule A, it seems to be more like an area of inquiry request. Can you speak to that, Ms. Hickey?
Yes, Area A should definitely be an area of inquiry request.
Okay, but then it also talks about documents as well, doesn't it? Or no? Hold on. Like number 8. So the ones I think that we're talking about are Schedule A, number 7 and 8. And number 8 talks about bills, estimates, invoices, etc.
Yeah, we would want to inquire to CMR about any bills or estimates that they may or may not have provided to the homeowner, as you know, they were pretty involved with the homeowner during the span of this claim. You know, to my knowledge at this point, that only includes one estimate. But you know, we would just want to ask CMR that same thing, whether there were any bills provided to the insured or any invoices provided to the insured while they were frankly in a contract with them. They did sign an agreement with the insured to do the work and prepare an estimate. So those are just questions we would want to ask.
But number 8 isn't limited to the subject's home, right? It talks about at other residential properties, and it talks about homeowners / tenants in general. So are you trying to limit it to just the subject property, or are you trying to get this information as to all other properties that CMR essentially has ever worked on?
I'm sorry, are we talking about 8 on Schedule A?
Yes, I believe so. Looking at the motion, it has 4 bullet points, and I believe the first 2 bullet points on Schedule A are number 7 and number 8, if I match them up correctly. And then the 3rd and 4th bullet point in Schedule C, I believe, are numbers 4 and 5 of Schedule C. Is that
You are correct, yes.
Okay.
Yeah, typically the extent to that question would really go to any neighboring properties. We think it's relevant if CMR has done work at the neighboring properties in the immediate area of the subject property. That's not something I think is a huge part of what we would be asking them, but it is pretty typical of us to, request any information about whether they performed work at the neighboring properties.
Okay, and then as to numbers 4 and 5 on Schedule C, are you asking them to create a list of suits?
That in those, again, until they get named as an expert, that's not something that I would see coming up in this deposition. I'd have no issue, withdrawing that at this time.
Well, I guess we have to get to the bottom of this issue that's been raised today about whether this is really an expert deposition or not. You're saying, Ms. Hickey, that it's not intended to be an expert deposition, and that it's just intended to be a fact?
It was not intended to be an expert deposition. No, it was intended to be a fact deposition. And Ms. Rossi, I apologize if there was a miscommunication. You were definitely speaking to me, and I don't mean to misinterpret or say that you did not advise that. I think there was some miscommunication. My understanding was that you wanted a protective order prior to the deposition, and I wasn't exactly sure why we didn't speak about exact issues. I did push the deposition from February until May to give the opportunity to file the protective order and come and have it heard. So I had no issues with that. I just think that maybe our prior discussions had miscommunication, but I want to depose CMR as a fact witness for their involvement in the claim. As I stated, we're still pretty early on. We don't have a trial order or even an order to non-binding arbitration or anything yet in this matter. And I'm simply trying to obtain the facts regarding the claim at this point.
All right, Ms. Rossi, any responsive arguments to any of the questions that I've asked Ms. Hickey?
As I stated, this is someone that I have designated to be an expert. Whether they intend to depose them as an expert, I don't think really is the point. I think it's the fact that we have designated them as such. The rule doesn't require us to file a formal designation. We just merely need to let the other side know. And again, just these areas of inquiry, the general business practices, the handling of other unrelated properties. I understand counsel is neighboring properties. I don't know what that means. That's again very vague and can be interpreted as very broad. The only property that is relevant with respect to this claim is this specific property. And again, it does, Schedule C does imply that they should make a list of cases where they have been listed as a party. That's so beyond the scope, that's irrelevant, that's overbroad, that's unduly burdensome. It's just completely unnecessary to the facts and circumstances that involve this litigation.
All right. Just for my understanding as background, has CMR actually performed work at the subject property, or are they just provided an estimate for future services?
No, they have not done the work, any work at this point, no.
Okay. All right. Well, all I have before me right now is the notice itself and the motion. The motion asks the court to limit the scope of Schedule A and Schedule C, at least the 4 items that have been identified. You know, this whole fact witness versus expert witness, I don't know that I need to decide that. I think to some degree the answer is going to be the same either way. If you're taking this deposition as a fact witness who inspected the property and provided an estimate, I still don't see how general business practices for other properties or general handling of these types of claims is relevant to this particular case, especially if you're not doing it as an expert deposition. So I'm going to sustain, well, I guess this is a protective order, so I will be granting the protective order as to numbers 7 and 8 to limit it to practices for this particular property, which is the only one that's currently at issue. So to the extent that CMR was involved in either doing work or preparing an estimate or what have you with regard to this property, those questions can be answered, but I don't think it should go beyond the subject property into general practices. As to this list of suits in which CMR has been listed as a named party, first of all, as to a document request, you can't make somebody create a document for purposes of a document request. Even if there was an existing document that listed all the cases in which they were a party, I'm not sure how that's relevant to a fact witness. And then as to if it is an expert witness, you usually only list the cases in which you were an expert, not cases in which you were a party. So I think as drafted, number 4, the motion should be sustained as to number 4. And then number 5, again, that would be relevant if it's an expert deposition. So, and it wouldn't, because Rule 1.280 does allow you to inquire as to that regarding an expert, but you said you will withdraw that, Ms. Hickey, so.
If we are able to reserve the right to redepose them as an expert, because as I stated, we don't have expert opinions as of yet. So I'm either going to have to not take this deposition until we have to, give our expert disclosures and opinions, or I'm fine with, having that be sustained and reserving the right to potentially redepose CMR based on expert opinions when they're available.
Response to that, Ms. Rossi?
I mean, I don't think it's a very good use of everyone's time to have to go to 2 depositions. So, I mean, I'm designating them as an expert. Whether counsel chooses to take their deposition now or later is, completely up to her. I don't mind canceling this and rescheduling for, a later date, but I wouldn't be agreeable to sitting for deposition twice. I mean, that's just, honestly, not a very good use of everyone's time.
Normally, there's been some kind of disclosure of what the expert's opinion is. So I don't see a case management plan or order in your case yet setting forth deadlines to disclose the expert opinion. Usually there's a deadline to disclose the witness and the opinion, and then a later deadline to complete discovery regarding experts. So, just saying you're going to call them as an expert doesn't necessarily put the other party on notice as to what the opinion is, which would normally be designated in some way, either in a written discovery response or in a report of some kind that's been provided. And that way the other party can depose the expert as to their factual basis and opinions for their opinion, I should say. So have you provided the opinion yet, Ms. Rossi?
We have not provided the opinion, but we did notify the defendant pursuant to 1.280 that we were going to be designating them as an expert. If, like I said, I think maybe the best route, if Ms. Hickey's agreeable to that, is to just postpone this deposition. As the court has mentioned, some of these areas wouldn't be relevant regardless of what kind of a witness it is. But I mean, that's up to her.
Ms. Hickey?
Yeah, I mean, that may be the best course of action. Frankly, I have to state that it's, again, in this fact pattern, CMR is very involved from the initial reporting of the claim to being there at the site inspection to having a signed agreement. So while I understand, in the essence of trying to save all of us time and stuff, it is simply from gathering, again, fact-based information, it's just going to delay a little bit, the information we can obtain and understand based on what CMR did do at the property, whether they have made any repairs, just those typical questions that we would ask in a lot of these cases that CMR, it has not come up that they are being designated as an expert, therefore we can't talk to them about their agreement with the insured, what they did at the site inspection, why they created this estimate pre-suit, and why, they signed this agreement prior to the insured reporting the claim. So that's really just the information I'm seeking. I can push off the depot. I think it will just delay the case, but if we're not really close to any settlement negotiations at this point, then, if that makes it easier for plaintiff's counsel, then I'm willing to do that.
Okay, so just for my purposes, I need to be clear about whether you are affirmatively agreeing to push it off, Ms. Hickey, with regard to waiting for the expert opinion designation or not. Because if you're not agreeing to it, then I'm just going to roll in the motion as it is right now and announce my, and I can always add that subject to a later agreement to maybe push it off. And then that way, if you want to decide to do that after the hearing today, you can. I have to do a report and recommendation setting forth my findings based upon what's presented to me. And you have that 10-day exception period to disagree with me if you would like. So I just want to be very clear about what you are and are not agreeing to on the record.
I'll agree to it. I'll agree to push the depot.
Okay, so to be clear, you're agreeing to push the deposition of CMR until after you have the expert designation so that the entire deposition can be taken at once with regard to the fact information as well as the expert information. Is that accurate?
Yes.
Okay, so given that, I think Ms. Rossi, you still want me to rule on the scope of the deposition because you thought that it was always going to be an expert deposition.
Correct.
Ms. Hickey, go ahead.
We will, when we reset, again, in the efforts of time and judicial economy, we will likely be filing a different notice of taking deposition to include different areas based on them being a fact witness and an expert witness. So I'll have to amend the notice anyway.
So I think that makes the motion moot for this particular notice if this isn't going to be the notice that you're going to operate under. Do you dispute that, Ms. Rossi?
I mean, yeah, technically it makes the motion moot. I'm hoping that if the lack of an order today from the court, I just hope that doesn't result in us having to come back and discuss this all over again. Do you know what I mean?
Well, I don't have a crystal ball as to what the notice might ask for a new deposition that is intended to include expert information as well as fact information. So, given the agreement to renotice for a future date, which would include the expert opinion information, I think it does render this particular motion moot, and the parties would have to, once that new notice is filed, if you have disputes regarding the scope, it would have to come back before the court for determination. Other than to generally say, we know what the scope of expert discovery is. Based on the rules, I would encourage you to confer amongst yourselves regarding any disputes before filing a motion for protective order to try to avoid the need for a hearing. But I think it does render the specific objections here moot if they're not going to be, if I don't know if they're going to be included in the later notice.
Sure, and I mean I do agree with that.
Okay, so to summarize, Given the agreement of Ms. Hickey to reschedule the deposition of CMR after the expert opinion disclosure has been made in order to be able to take all of the deposition all at once, that moots the subject motion for protective order. And if the parties, if the issue, you have to refile a new motion if necessary upon the new notice of deposition.
Okay, that's fine.
All right. So as I think I mentioned already, there's a 10-day exception period that applies unless waived. You want to preserve or waive that time period based upon the findings that I've announced on the record today. Ms. Hickey first.
I'll waive.
Ms. Rossi.
I'll also waive.
All right. So I'm going to ask, it was the plaintiff's motion, so I'm going to ask Ms. Rossi to go ahead and submit a report and recommendation that sets forth the findings and essentially the agreement that was ultimately reached on the record today, finding that this motion is moot, but it did provide for the rescheduling of the deposition into the future. So I have a template available on the Magistrate downloads webpage. If you could submit that, please, by email and Word or through the portal after circulating it to Ms. Hickey. Since you've waived the exception period, I hope you'll be able to reach an agreement as to the wording of that report. If you can't, please let me know what the disputes are. I like to receive those within a week of the hearing whenever possible. Do you have any questions or clarifications from either party while we're still on the record?
No, I mean, I'm just going to put in that, the motion's moot and that, based upon, the agreement that we'll hold off on the deposition until after the expert designations are required.
Right, and I would note that you all are well past the time period within which you should have agreed to a case management plan or order, order. So I'm kind of surprised that you haven't already been set for a case management conference, but I would encourage you to try to reach an agreement in that regard so that you have deadlines in place so that the case can stay on track to be concluded within the standard track, okay?
Okay, we will work on that. Thank you so much.
No problem. Ms. Hickey, did you have anything else you wanted to clarify or address on the record?
No, thank you.
All right, I hope you all have a wonderful afternoon. Thank you.
Thank you, you too. Bye-bye.
Take care. I don't have anybody in the waiting room yet for 1:30. I'm going to check to see if there's a cancellation notice. Well, there's a cancellation notice for a hearing in front of Judge McHugh, but that wouldn't apply. Oh, notice of cancellation for 1:30. Canceled. Oh, at 12:47 p.m. All right, so I believe that leaves 2 o'clock and 2:15, and that would be all for this afternoon.
Okay.
Unless we get another cancellation, in which case I'll let you know. But Mr. Diaz did already show up thinking it was at 2, so I'm assuming that one's going to go forward, and the guardianship one will go forward. So
Okay.
I will